Interests in all types of business organizations form community property. This includes shares in a corporation, membership units in an LLC. Stock options are considered contingent property rights rather than mere expectancies, and options are treated as community property. A partnership interest in a partnership is community property, but is also governed, of course, by the partnership agreement. An ownership interest in a sole proprietor is community property, even if the business is a sole proprietorship in the name of one of the spouses. The other spouse has rights to half under the rules of community property. When a business is acquired before marriage using separate property funds of one spouse, the question arises as to whether the business is community property. And the answer depends on the time and energy invested in the business by the married couple. If the time, labour and skill invested by one or both spouses during the marriage is significant, the business is community property, except for the initial investment and a reasonable interest on the initial investment. If, however, little time, labour or skill is invested by one or both spouses during the marriage, the business is separate property, except for the income it generates for the community. If no time, labour or skill is invested, the business is all separate property. Rents, issues and profits arising from separate property are also separate property. When a business is acquired with separate property after the marriage, rather than before the marriage, the same rules apply. If the business was acquired partly with separate property, unless there's an agreement otherwise, it's presumed a gift to the community. The status of a business acquired entirely with separate property after the marriage depends on how much time, labour and skill is invested by either spouse. If the investment by the community is high, the business becomes community property. If there's no investment by the marital community, the business is kept separate and not commingled, then it remains separate property. On divorce, the court has the task of dividing community property equally or substantially equally between the spouses. Dividing a business can be something of a challenge. The judge can order the business to be liquidated and the proceeds shared. This is somewhat harsh, and liquidation of the business is unusual unless the business is to be shut down anyway. Alternatively, the judge can assign the whole business to one partner with a substantially equivalent offset to the other. The shares in a corporation can be equally divided between the spouses. Likewise, membership units in an LLC can be divided and shared among husband and wife. What is a business worth? Well, the business is worth what a willing purchaser would offer for the going concern in an arm's length transaction. If there are no willing purchasers and no arm's length transactions, then the value is open to some speculation. Discounted cash flow, net asset value, earnings capacity, comparables and other techniques may be used. Business valuation is recognized as an art, not purely science, and often comes down to an in-court battle of the expert witnesses called in by each side to provide a favourable valuation. If the business is a going concern, it's valued at more than just the book value of the assets. Goodwill can be factored into the calculation.